truth, logic, common sense, that gut feeling, and yes, even a little psychoanalysis, as we are once again together, you and I, to discuss Chad and Lori Daybell. Yesterday, when all of this news came out, old KJ got blue. I got to thinking about everything that we've been through all this time. I want to thank all of you that signed the petition to get cameras in the courthouse. Although it didn't happen, I want to personally thank all of you for taking the time to do that. And to those that sent letters to Judge Boyce, thank you so much for showing your love, showing your commitment to get justice through understanding. Of course, it didn't work. Many of us are very disappointed. And, you know, I realize that, you know, it's a lot bigger than us just wanting to watch this trial live, you know. As we're going to go over today, one of the reasons that Archie wants the death penalty taken off the table for Lori is the media saturation. And Judge Boyce, even though we don't want it to be so, did the right thing. This is a way to cut Lori off at the knees so she can't say that she didn't get a fair trial. Now, I want to go over this with y'all. This order governing conduct, Madison County remote viewing location, and the news coming out. I posted it on the community wall, the article, along with Nate Eaton's little 7-minute deal talking about this, y'all. No designated seating for media members. You have to make a reservation the day before. And the audio files cost $5 for the first 20 minutes and 25 cents per following minute. And you know and I know that East Idaho News has already come out. Nate said it on his little interview there. They are going to be providing every evening the audio of the day's hearing. So we're going to get that. We're going to go over that. And you know there'll be a lot of media organizations willing to pay that kind of money for this trial. This trial is going to be absolutely huge. In fact, they've got in Ada County, he's talked about a media, not just the media, but anyone who comes to the trial. There's going to be an overflow room there in Ada County, and they're going to do a viewing room in Madison, Rexburg over there. They're going to do that as well. As some of y'all have pointed out, this really isn't fair to some of the victims' family members that live in Louisiana, Utah, Arizona. This is going to be a 10-week trial, at least 8 to 10 weeks. Probably less than 10 weeks now that Chad's not with Lori. But still, that's a lot to have to deal with for these victims' family members. Now, I want to say this, and I want to make this channel announcement to y'all, and I think many of y'all saw this coming. OKJ is not going to the trial. Wayne and I sat down last night, went over all of this, and I'm going to go over with you today in terms of the way that this trial is situated now. And we had already we already had the baseline, the foundation of our hearts, feeling like we didn't want to be there and be part of any people that are going to be the circus and all this. These family members are going to be hurting. They're going to have to see things and deal with things. And Wayne and I just do not feel comfortable going there and being in the middle of all that. Because really, ultimately, if you want to look at it like this is another reason as well. Initially, I had made basically a promise that I was going to go to this trial. And y'all know I'm a woman of my word. But there's one thing that will make me have to come back on a promise, and that is when things hit me. And I realize that it's not about me at all. Who we should be listening to during this whole trial is Cresha K. Easton of Difficult Research and Larry and Kay Woodcock, or other victims' family members, but specifically the Woodcock family in Crescia. Those are the people we want to hear from. Now, will they get with us every day? I don't know. They might not ever say anything. Maybe they have to stay focused in order to hold themselves together. I don't want to see any pressure on them whatsoever. They've got to go and relive this. And they're going to learn things that they didn't know. And so all I'm saying is if anybody is going to be at this trial that wants to discuss their narrative or the way that they see things, what their lens is seeing, whatever it is, it should be the victim's family members and not some old country girl and country bumpkin husband from Tennessee. We love Larry, Kay, and Crescia. We want what's best for them. And if you look at it in a bare bones level, aside from that being the priority, we're talking about overflow rooms in Ada County. I'm not guaranteed. Wayne is not guaranteed that we'd even get a seat. If we decided to go to Madison County and go to their location there to view the hearing, well, we wouldn't even want to do that because then we wouldn't even be close to the people we love and care about. And that's Crescia, Larry, and Kay. So we wouldn't want to do that either. What I am going to say is I apologize that I really intended to go. I really wanted to, but some things are just more important. Some things are just more important. And that is these victims' family members, they're going to be going through a tough situation. And I don't want to be there in the middle of all that. I just don't. With no guarantees on top of it all that we'd even get a seat in there. I mean, when you're talking about reservations and hopefully getting into an overflow room, it's just not feasible for us to take the time off in hopes that we could watch the trial. So we're going to be with you. I'm going to be with you every day that Nate Eaton of East Idaho News or another media organization releases the audio, and we're going to go through it together. And we're going to get justice through understanding in all this. As I've said before, if anyone is prepared to hear this trial, it's all of us on here. We've worked so hard and diligently to get justice through understanding. We've tried to fill in those pieces to ready ourselves. So we're going to go over this very quickly because y'all can read the article and listen to Nate on the community wall. But I do want to point out a few things, and then we are going to get to some really important motions. A motion to compel by Archibald, a motion to dismiss the death penalty from Archie, and a motion in limine to exclude late disclosed evidence from Archibald. We're going to go over these things, and this might take a while. But folks, listen, it's all going to work out the way it's supposed to. Let us stay strong for Crescia, Kay, and Larry, and the rest of the victims' family members. Let's get justice through understanding. Let's share what we find out, our perspectives as every day goes by in this trial. It's going to be here before we know it, y'all. But the order governing conduct, this is specifically about the Madison County remote viewing location. As I've said before, in Ada County where the trial is taking place, they're going to have an overflow room. But this is talking about the judge has kind of give a little bit. And the reason I believe he's given a little bit is because they had to sever these cases. Now the citizens have to fit the bill for 2 trials. And maybe the judge thought, well, you know what? They're the taxpayers, and this was the community that was affected, and so we're going to do this for them. And at least that is something that I think should have immediately been done in all of this. Pursuant to the order governing courtroom conduct in Ada County, issued by this court relating to the upcoming jury trial in this case, the court is issuing this further order governing conduct with regard to a remote viewing location in Madison County Courthouse. Said remote viewing location will be chosen by the Honorable Dane H. Watkins, Jr., Administrative District Judge of the 7th Judicial District, and may be changed from time to time as deemed necessary by Judge Watkins due to other Madison County needs. Therefore, pursuant to Idaho Court Administrative Rule 45 and 49, the court orders as follows. Seating and attendance in Madison County remote viewing location. A. Viewing of the proceedings. The overflow and remote viewing locations are being offered only for the portions of the jury trial that are public, subject to the technical needs and possible periodic interruptions due to technological issues. B. Seating for the victims' families of the defendant, counsel, other court personnel. Certain seating may be reserved for members of counsel, authorized court personnel, security personnel, and the defendant's family and victims' families. So there is going to be seating for the victims' family members that are going to be reserved, and I'm assuming right up front there. It's so absolutely pathetic that they're going to let the defendant's family members sit over there and have reserved seating. Sorry, y'all, but I just don't think the defendants deserve shit. Public seating, subject to the need for reserved seating referenced in 1B, seating for the public will be permitted as space permits on a first-come basis, subject to a reservation system to be administered by the 7th Judicial District's Court Administrator's Office. Details and instructions regarding how to access the reservation system for seats in the Madison County remote viewing location will be published on a website. So you just stop and think about where our judicial system has gotten to at this point. I mean, yes, we know that he is not allowing live camera feeds in the courthouse because he doesn't want any prejudice for the defendant. She wants a fair trial and all this. And you got Archie, which we'll go through, is talking about this media saturation. Well, the judge has cut back on that. So they don't have that argument. But what it has gotten down to is now, if you want to watch your judicial process being played out, you gotta make a reservation the day before. This isn't a damn restaurant. This should be wide open for anyone and everyone to see. It's sad. And it's a fine line between it, I understand, and I know for the most part. The victims' family members have made themselves clear as they wanted cameras in the courtroom. They wanted the world to see it. That's what Larry Kay and Kresha wanted. But it ain't happening. And as of yesterday, March 7th of 2023, you can go on that website and make a reservation to go to the viewing area in Madison County. And of course, they have a reservation system in Ada too. They say the court room that Lori's going to be tried in is small. So they have to have an overflow at Ada County. And now they've extended that into Madison County as well. There will be no priority or designated seating for the media. No person may reserve seats except through the reservation system addressed above. Seating in front of the bar, and y'all know that bar thing I told y'all I'd like to jump over and beat the shit out of Lori. No one other than the court personnel designated by the court or the court's designee shall be permitted to access or sit in front of the bar of the courtroom remote viewing location without specific authorization. Entry and exit during court proceedings, spectators with a reservation may be permitted to leave and re-enter the remote viewing location during a court session as long as there is no significant distraction to other spectators, i.e. if somebody's got to go to the bathroom, but they're talking about if someone keeps coming in and out of that area to maybe report or whatever, it might distract people and then something will be done. Entry and exit during court proceedings. Spectators with a reservation may be, okay, I've done said that one. Other restrictions and requirements within the Madison County remote viewing location. They'll have a security screening where they're going to check all handbags, backpacks, and other carry-ins, like they normally would anyway. When Wayne and I went to the Ada County Courthouse, they had metal detectors. They checked you. They made sure you didn't have anything like that. Cell phones and other electronic devices in remote viewing location. Now, remember, this is about Madison County, but it's talking about Ada too, because at the beginning it talks about pursuant to the order governing courtroom conduct in Ada County. So it's basically given the same rules, right? Cell phones, pagers, laptops, or any other electronic devices shall be turned off or be put in silent mode and shall not make any sound or create any distractions. Devices shall not be used to record, photograph, or transmit any sounds, images, or video from the remote viewing location. Laptops may be used in the remote viewing location if cameras and microphones are disabled. And that's how Nate Eaton was able to tweet out the last hearing that Lori and Chad had when they severed the cases. Nate was able to, well, it wasn't Nate, it was a woman that was taking over for him while he was on another case. But anyway, they were able to live tweet. And so we'll get some of that too, and it will all be put on Community Wall before what, y'all? Every day after trial, an audio will be released, and we will go over it together. Under no circumstances may such laptops be used for any audio or video recording or transmission or photography of the court proceedings being projected or of any persons attending the remote viewing location. Now, they're talking about Madison County, but you know, Ada's included. They both have I guess you'd call, in Ada it'll be an overflow room, and then in Madison will be a place where people can go and watch it on a screen. It's called a remote viewing location. No media interviews or reporting shall be conducted in the remote viewing location. So you could almost see like a reporter standing there while this is going on. We're here at the remote viewing location. That's not going to happen. There's not going to be any media that's going to be able to report or have any media interviews, like, you know, asking somebody, well, what do you think of this so far? You know, it's not going to happen. Disruptive behavior. Any activity or behavior which is considered disruptive may result in removal from the remote viewing location. Any spectator who creates a visual or auditory disturbance may be removed from the remote viewing location and or the building at the time at the discretion of court security personnel. It talks about Idaho Rule of Evidence 615. Witnesses subject to the exceptions provided therein shall be excluded from the remote viewing location. Court security or personnel are authorized to check names and restrict access to the remote viewing overflow location of any attendee who is a potential witness for the trial. No one may wear any buttons or have any item that displays any message of any kind or engage in visual or auditory disturbance or disruptive behavior in the remote viewing location. And this is where I have to part ways with this, because we're talking about this ain't at the courthouse in Ada County. This is in Madison County. And people should have a right to wear Justice for J.J. Tiley bracelets or buttons or shirts or whatever the hell they want to do. We're talking about First Amendment rights here. It'd be different if they didn't want that in the trial, in the courtroom, that the jurors could see it. It's stupid. It's ignorant. Any violation of this order and any conduct the court finds disruptive of proceedings may result in an order for temporary or permanent exclusion from the remote viewing location during the trial and may be subject to criminal contempt of court. Any attempt by anyone without prior leave of the court to contact, communicate with, photograph, or video, audio record any member of the jury panel respecting this case in any location until the conclusion of this case may be punished by criminal contempt of court, and that goes without saying. The jury is supposed to be sacrosanct. Leave them the hell alone. And this makes me believe This isn't going to be there's not going to be, obviously it's been ruled, no sequestration of this jury. So they're going home every day, is what they're doing. Any person violating the terms of any portion of this order may be removed, and any recordings or images violating the order may be seized or deleted. In addition, the person in violation may be charged with contempt pursuant to Idaho Code Section 18-1801. And so there you go. There is the whole thing set up since yesterday. There's a website. I'm sure that people have already started reserving their spot. And Ada County's going to have an overflow room, but I can tell you this right now, not everyone that wants to be at that trial is going to get in, even with the overflow room. I don't believe. I believe it's going to get full. I think it's going to be, this is just my opinion, y'all, that it's going to be a freaking circus. And that's so unfortunate for the victims' family members. There are going to be a lot of people that are going to be coming to that. And I can't help but think about Cresha, Kay, and Larry. I know they can take care of themselves. They will. They'll have extra, I'm sure, staff there that's going to keep, make sure they're safe, that the media doesn't absolutely try to bombard them as they go to the bathroom or maybe out for a smoke break. I know Kay and Larry don't smoke. Cresha does every now and then. I just hope nobody bothers them, because I love them and I don't want to see anything bad happen. So that is the news. And also the news that Wayne and I will not be there. We're going to be here with you. And we're going to be waiting with bated breath for anything Cresha has to say, if she feels up to saying anything. And we're going to continue to be supportive of her. And we're going to support Kay and Larry. We're going to do our very best to get through all of these audio days every single day. We're going to meet at the same time every evening after the audio's released. I'm always going to put it on the community wall. We're going to go over it together. So since I did, I told y'all I was going, and I'm not going now. And because I told myself that I wasn't going to be doing any live streams anymore, I'm going to be doing some live streams on this court case to make up for that. Because we're going to need to put our heads together and interact during all of this. And so that's why I'm doing it. Because y'all, all of y'all know that I told y'all as soon as this case is over, the adjudication of this case is over, KJ is leaving this channel. That's just the way it is. That's one thing I know for sure over anything else. So we're going to do this together. And we'll just watch it unfold. So as we've always went over legal documents, these legal documents will blow your mind. I kind of expected all this from John Pryor, but since he's got all the time in the world now for Chad, they haven't rescheduled a trial for him yet. And he can take a breather and get a hold of his flask and drink and put shit off even longer. You mark my words on it. When they give Chad Daybell another court date, and it's 6 months down the road, as the trial gets near, John Pryor will continue his bullshit. That's just the way it is. That's how this man operates. He got his way. But I want to get into these motions from Archie because they are very fascinating and they make it very clear a lot of areas that I think I'm waiting actually for the state to respond to these, which I'd rather come at you with the state's response. But let's go ahead and put on the record what Archie's concerned with. His motion to compel. Comes now defendant Lori Noreen Vallow Daybell, by and through her attorney of record, and motions this court for an order compelling the government to disclose all unidentified information as requested. Rule 16 requires the prosecuting attorney at any time following the filing of charges on written request of the defendant to disclose the following information, evidence, and material to the defendant. And this is what Archie wants. And I want y'all to listen up. Statement of a co-defendant. On written request of the defendant, the prosecuting attorney must permit the defendant to inspect and copy or photograph any written or recorded statements of the co-defendant. Upon information and belief, the state is withholding material evidence that is not in the possession of the defendant and is needed for the preparation of the trial. The defendant's counsel on March 6th of 2023 was provided 2 audio files containing approximately 60 minutes, y'all, an hour of audio statements of co-defendant Chad Guy Daybell. And what counsel believes are conversations with individuals identified as witnesses in this case. Now, this is what I think this hour thing is. I think it was the one where he was talking to Melanie Gibb. She is a witness in this case. But he goes on here and he says, it is the belief of the defendant that the state of Idaho may be in possession as a conservative estimate based on the number of weeks that co-defendant has been jailed pre-trial of over 100 hours of audio recordings of a co-defendant that has not been turned over to the defense in this case. And he bases this 100 hours that he thinks are statements from Chad Daybell on this. Listen up. He bases that on the nature of the conversations heard by counsel for Lori Daybell. There are likely materials within the same that may be material to either guilt or punishment. The defendant will not, nor should we be compelled to discuss in this motion our theories as to why we believe this information is potentially material. Simply put, the defense doesn't know what the defense doesn't have. The state of Idaho is required by the court rule to turn over the evidence. So he's saying basically, we think there's more statements, recordings, audio recordings of Chad Daybell, at least 100 hours, because as we know, there are at least 100 hours of Lori Daybell. So shouldn't there be just as much of Chad Daybell as there is Lori? That's what Archie is saying, y'all. As the court will recall, this court admonished the state previously in another hearing regarding the need to turn over all evidence under Rule 16 as the defense for Lori Daybell argued that the state of Idaho was damming up discovery and releasing it at its convenience. The state indicated that it had turned over the bulk of the discovery. Now here we are again, says Archie. The defense is now requesting that this honorable court compel the state of Idaho to turn over all statements of the co-defendant in this matter. For the foregoing reasons, the defense respectfully requests that the court require the state to turn over all material requested pursuant to Rule 16. Furthermore, now listen to this, the defense requests, based on the multitude of discovery violations, the late disclosure, and practical impossibility of the defense being able to review the statements of co-defendant Chad Guy Daybell and any other discovery that the state is required to produce, that the court dismiss the defendant's case. And you know that's not happening. But when you've got a defense attorney filing a motion to compel, and at the end of it, he says, we are asking also that you dismiss this case, they are desperate. There is no reason why they shouldn't have said on their filing, motion to compel and motion to dismiss. He says it right at the end of that, y'all. So there you go. Chad Guy Daybell, his audio recordings. We know what was said in the Chad's preliminary hearing. I believe that's what they're talking about. There might be other recordings. It says individuals that he was talking to. Could these be jail recordings? Could this be before he got arrested? Was anybody recording him? When he got arrested, did he make any audio recordings in his interview? Did he even have an interview? You know, I was thinking common sense. Him and Lori wasn't going to say shit. They probably didn't get an interview. But why would the defense be asking for 100 hours? Because even if the state says there isn't 100 hours of Chad Daybell's audio recordings, the defense has just pointed out that Lori Hussey Daybell has at least 100 hours. So there you go. That's the motion to compel/dismiss. But then you've got Archie talking about motion to dismiss the death penalty. And this is kind of laughable. But, you know, what do you expect? I mean, he's got to defend his client. He says, and this was filed 2 days ago. It says, come now, the defendant through his attorney and her attorney and pursuant to the Constitution of the United States, he wants a motion to dismiss the death penalty. He says there are still defense motions pending which have been argued and submitted to the court but not yet ruled upon. As the court determines its decision on the submitted constitutional motions, the court should also dismiss the death penalty for the following reasons. And y'all remember a while back, he had all these motions about, it was like, 7 to 11 pages worth of constitutional things. He talked about the death penalty is unconstitutional. He talked about all these things like, you know, why she wouldn't be getting a fair trial because she's a woman and all this other stuff. So here are the reasons that the court should dismiss the death penalty according to Archie. Number one, media saturation of this case is still persistent. Even though the court has tempered the media exposure to potential jurors in Ada County by expelling cameras from the courtroom, the risk of the media tainting the juror pool is still great. Non-stop articles about the case and the rehashing of the arguments at each hearing continue to expose potential jurors to prejudice and bias against the defendant. And folks, before this trial starts, we're going to go over the jury questionnaire along with jury instructions. They can weed these people out. Again, I've said it before, and many of y'all have talked about this as well. Just because someone knows about the Chad and Lori Daybell case, and they tell them, hey, yeah, I've heard of it, I've seen articles on it or whatever, that doesn't disqualify them. It does not disqualify them. In other words, there don't have to be 12 jurors that's never heard about this case. Number two, there have been multiple discovery violations by the government in this case. And, you know, I don't know what to say to that. I just don't know. It says the discovery is admittedly voluminous in this case. The government has Bates stamped over 80,000 documents in this case, yet has admitted that it's just the bulk of it, not all of it. The government admitted this past week that there were more statements of the co-defendant Chad Daybell. So there you go, y'all. Just this week, the state has let Archie know, hey, we've got statements from Chad Daybell. And, you know, I am sure they turned over that audio recording because of Chad talking to Melanie Gibb and all that, because they saw that in Chad's preliminary hearing. This has to be something else that the state has got. I am so sure when this trial starts, we're going to hear it. It's going to be absolutely mind-blowing, y'all. Defense counsel don't know what we don't have. It could very well be Brady information. If there's a death sentence in this case, appellate lawyers and post-conviction lawyers will inevitably find additional discovery that has not been turned over, as the government has essentially admitted it hasn't turned everything over. Such discovery failures will cause any death verdict to be vacated and the case will start over. And let me just be clear on this. If she gets convicted and she got the death penalty, right, which I don't believe she will, and we'll go into that further, because he gives us reasons why she shouldn't have the death penalty, which is exactly what we've all been saying. She has a mental illness. The bottom line is if she got the death penalty, it would kick in appellate issues where they would go over everything. Everything. And if they found something the state didn't turn over, that right there, that automatic appeal right there. Let's hope the state will get their head out their ass. The government wanting to kill a mentally ill person is a troubling thought. You know what's a troubling thought? Is that this damn whore, I don't care if she had a mental illness or not. What's troubling is she murdered JJ and Tylee. She conspired to murder Tammy, and she murdered Charles Vallow. Okay? That's troubling. Another thing, there are millions upon millions of people with mental health issues that do not go on to murder people. If that's the case, if a person can be kept off a death row, they can commit atrocious, evil crimes, and I've got a mental illness, so I'm not going to death row. Nobody, absolutely nobody would go on death row. So he can just shit in one hand and hope in the other. The fact of the defendant's mental illness is known to the court and the government. This past week, the government submitted an opinion that maybe the defendant, this past week, y'all, the state says that maybe Lori wasn't mentally ill, but just evil. Ding, 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 ding. The state told Archie that maybe she wasn't mentally ill. She was just evil. Look at that, y'all. Look right there. Look. She was just evil. Well, there you go. We got a little truth coming out. Damn. Heck yeah. I'm glad the government's taking this position, because there is a such thing as evil people, mental illness or not. And she's evil as they get. She's diabolical, and Chad Daybell is as well. Even if the government's new opinions of the defendant has some believers that the defendant is just evil, we don't kill witches anymore in America. Now let's stop there. Let me repeat this. This is in a legal filing from Archibald. Think about this again. Even if the government's new opinion of the defendant has some believers that the defendant is just evil, we don't kill witches anymore in America. What the hell? This woman was more than a damn witch. She was a damn zombie herself. And let me tell you something. Evil is real. It's real. It's just as real as mental illness. And for him to use the analogy witches, the Salem witches, folks, let me just be clear. This woman is past a witch. Christina Atwood, Nicole Earle, Melanie Gibb, all these women that got in this damn casting with their arm to the square, whatever the hell, that is a witch. That is someone who doesn't see themselves as a witch, but they are. They're a witch. Nobody has the power to do shit when it talks about taking people out. How dare somebody say, I'm going to use my spiritual powers to kill Charles Vallow. Think about that, y'all. Think about that. The state of Idaho doesn't have chemicals to kill people on death row is another reason Archie doesn't want her to have the death penalty. And I put on the community wall that Idaho's considering a firing squad. Well, let's just get it going. Let's get them damn guns shined up, huh? Let's get some target practice going. The government has tried mightily to kill Gerald Pizzuto on death row for 35 years. The Idaho Department of Corrections can't find drugs for killing, and so the execution hasn't been carried out. This has caused the Idaho legislature to currently debate a new law of assembling a firing squad, even constructing a new building for the human target. Moral decency certainly can't accept the thought of marching a blindfolded, mentally ill woman in front of a firing squad, and Archie needs to he wants a visual. How about Tylee being chopped up and burned up, and her remains scraped up and put in a melted green bucket? A beautiful girl. How about the fact that if JJ was dead before they put why would they put the bindings on his hands and feet? If he was smothered and dead, why would they have to put the duct tape around his jaw and mouth? That's what Archie needs to be looking at. That's what he needs to see. Give me a break. Even if the government secures a death verdict for Lori Daybell in this case, the new law won't apply. She will still be subject to the old law. In other words, even if the government is successful in convincing a jury to kill her, it will never happen. Well, I'll tell you what. If it don't happen, it don't happen. But the fact is she needs to have her damn ass on death row with Robin Rowe. They need to be each other's lovers for all I care. This is a capital murder case, and heightened scrutiny applies to the government's actions when it seeks to kill a defendant. There need to be, heightened scrutiny applied? A heightened scrutiny applied on whether someone is evil or not for what they did to those children, to Tammy, to Charles. I know Charles isn't in this case, but I always include Charles Vallow. I always do. She deserves to go down. However it works out, whatever is decided, whether she gets death row, whether she gets life in prison, makes no difference to me. I want her to come out of a prison in a box. That's what I want. One way or the other. So that's him. That's what he wants. He wants the death penalty taken off the table for those reasons. And I think they're stupid reasons. Media saturation, multiple discovery violations, the government's wanting to kill a mentally ill person, and y'all have heard me, and we've talked about it. I said she probably wouldn't get the death penalty because she does have mitigating things about her mental illness. The fact that she was faking it and malingering up there. I don't care what anybody says. She's a liar. She is a diabolically evil woman, far past a witch. She needs to be snuffed out, either out of society and life in prison or in front of a firing squad, as far as I'm concerned. Now, finally, I'm going to go over this motion in limine to exclude late disclosed evidence. And remember, we talked about a motion in limine, but this is important because what Archie's trying to say is because these are late disclosures, the state don't get to use it because we ain't had time to really prepare a defense because we've gotten these late disclosures. You'll see what I'm saying. Comes now the defendant through her attorneys, and it talks about the amended notice of trial setting, pretrial conference, moves to prevent the state from presenting all the evidence listed in the 13th supplemental discovery disclosure as follows. And remember, we went over the last one. I told y'all there was the 13th discovery disclosure, and we went over it. He's saying that none of that should be put in the trial. And before I saw this, I thought, damn, we're going to see all this in the trial because the state's turned it over in discovery. He talks about this stuff should not go in the trial, y'all. He says, paragraph 2 of the court scheduling order states that all discovery must be completed prior to February 27th of 2023. And y'all remember, Judge Boyce talked about that. And the state said, well, we thought that was the last day, but the judge said no, prior to that date. Whether it was a misunderstanding or not, y'all, as far as I'm concerned, the state knew better. I mean, they can say it all they want. It is what it is. It says this is a capital case. Murder case, and heightened scrutiny applies to the government's actions when it seeks to kill a defendant. And then he tells in his motion to exclude this evidence what it is he does not want in here. He doesn't want 702 disclosures, which is 140 pages. He doesn't want the Arizona certified documents, which are 25 pages. He doesn't want Dr. Green's report, which is 38 pages, Dr. Wellner's 36-page report. He does not want the FBI 9 audio files and 3,460 pages brought into this trial. He doesn't want the FBI sub-files brought in. He doesn't want any of the Fremont County 33 audio files and 441 pages. He doesn't want the psychic essay, whatever the hell that is. That's 76 pages long. I guess some psychics got involved trying to find the children. The Social Security, 252 pages. I'm sure that has to do with her Social Security fraud. The RPD, 3 audio files and 348 pages. And the PAC-TEC report, which is 8 pages. The discovery provided late is 4,933 pages and 48 audio files containing over 30 hours of interviews. Defense counsel and the defendant will not and cannot review all this material prior to the jury trial selection starting in Boise on March 27th of 2023. The only remedy available to the court at this time, since the defendant has maintained her right to a speedy trial, is to prevent the admission of this evidence at trial. He talks about specifically the FBI reports. He says preventing the admission of this late disclosed evidence at trial would include all of the witnesses identified in the FBI reports. These FBI reports begin with interviews in 2020, 3 years ago, y'all. For example, Audria Baratario was a friend of the defendant. She pleaded the Fifth Amendment when summoned for the grand jury. There you go, y'all. This Audrey woman pleaded the Fifth Amendment. You know why? Because she's a damn evil bitch. I'm telling you, this woman should have told the truth. You want to know what Audria Baratario said when she went to the grand jury? She said, I plead the Fifth Amendment. Why would she do that, y'all? Why would she do that? She's protecting the queen and the king? Give me a break. The government still listed her as a witness, and so the defense reached out to her to see what she was planning to say. She refused to provide any information to the defense. Then, less than 30 days before trial and after the court's discovery cutoff deadline, the defense received the FBI report containing the details of the interview with said witness. Her statements about the defendants are false. Her statements about the defendants are false. So, in her FBI, did she say something negative? Why would she say, I plead the Fifth Amendment 1 minute, but then in the FBI interview, she's telling them something that Archie thinks is false about Lori and Chad? So, you kind of left hanging in the air about that. All I'm saying is he confirms that this Audrey woman pled the Fifth Amendment would not help in the grand jury, but went on to sit for an FBI interview, and she probably shit her pants and told them some things because she had to. She knew if she lied to the FBI, she'd go down. And folks, make no mistake, Melanie P. probably pled the Fifth Amendment too. I almost guarantee you that. If the defense would have received this information in a timely fashion, we could have investigated the matter further. Instead, the defense is hampered and doesn't have the requisite time to provide an effective defense. Most of the interviews from the FBI were over 3 years ago. Why it took 3 years to provide these FBI reports to the defense counsel cannot be explained in good faith by the government. Then he goes on to talk about Michael Wellner. Remember, we talked about the state wanted to bring this professional, this doctor in. He says, Archie says, among the 4,933 pages of late disclosed evidence is an opinion from the state's expert, Michael Wellner. He calls it an affidavit, although it's not dated and does not meet the definition of an affidavit. The defendant is not presenting a mental health defense at the guilt phase portion of the trial. This has been the subject of multiple hearings, and the court has ruled upon the matter. The defense experts will not present a mental health defense under Idaho Code 18-207 during the guilt phase of the trial. And remember, Dr. Wellner was he was going to explain to the jury. He's going to say, there's a difference between religiosity and using your religious beliefs as an excuse to murder. Remember that? Archie doesn't want this doctor to testify in this. The government's current position regarding the defendant's mental health is not well received. The government knows of and conceded with her commitment to a mental health facility in the state of Idaho. The government has received and read all of the reports from the treating mental health experts, both in and out of the mental hospital. The government has received and read the mental health reports from the court's independent mental health expert. All experts who have met with the defendant agree that she suffers from a mental illness in varying degrees. Instead of accepting the mental health evidence for what it is, the government wishes to change the title of their expert from mental health expert to religious expert, y'all. An expert on what? Evildoers. Okay, we're in for it. This Dr. Wellner is going to be an expert on evildoers, y'all. And that lines right up with damn Lori and Chad. They're evildoers. Rule 702 of the Idaho Rules of Evidence prohibits what the government is attempting to do in this case. The court should review the CV of the government's expert and find that he has no such expertise in religious studies or the concepts of evil, y'all. Y'all, this case is going to bring out. Everyone's going to get to hear the audio at least, and whoever attends is going to be right there. But we're going to get the education, y'all, on evildoers and evil. Folks, this needed to happen for so long. I hate that these victims died, but this is going to enlighten so many people. There is a difference between mental illness, religion, and evil and evildoers. He isn't published in those areas and has not reviewed by peers in those areas. His testimony would violate the ABA criminal justice standards on mental health, because he's opined a canned mental health diagnosis of her without even meeting her, and because she's not presenting a mental health defense during the guilt phase of the trial. In fact, the concept of evil doesn't even exist in a psychological setting. Folks, that's pretty sad, isn't it? A psychological setting or a psychiatrist or a therapist, that they don't see that this evil is real. You know, that's just, it's absolutely pathetic. It really is. And the DSM doesn't recognize it. You know, I've always thought that people, these professionals, they look at the evil deeds of people and think they've got to be mentally ill to do this. You think evil people that commit these terrible crimes, when they meet with a psychiatrist about why they did it, you think they're going to be straight with them and tell them that they were demon possessed or that Satan did it? And even if they did, do you think these professionals believe that there is such an evil? There is, folks. There is. Dr. Wellner has not evaluated the defendant and has not requested to evaluate the defendant. It violates a doctor's oath to diagnose someone as not having a mental illness when the doctor hasn't even evaluated the patient. He's not entitled to evaluate her for the guilt phase portion of the trial, since the defense experts won't be presenting testimony during the guilt phase. As such, the government's expert cannot render an opinion, one way or another, that she does not suffer from a mental illness in the guilt phase portion of the upcoming trial, and that's Archie. Archie can say whatever the hell he wants. But the state has got a backstop to this bullshit about mental illness, that she had varying degrees of mental illness. Well, if they can talk about that shit and they're not presenting it as a defense, then the state's got to do something, right? And they're right on the money. She's evil. She's diabolical. The government wishes to call Wellner in its case in chief, as he states in his affidavit, The court should review his affidavit to confirm his position. The court must prevent this manifest injustice in this capital murder case. The court can do this by declaring it was disclosed late, which is true, and or by stating that the expert is not permitted nor qualified to testify under Rule 702. Since the defense is not going to present expert testimony in the guilt phase of the trial that she is mentally ill, the state cannot present a case that she is not mentally ill. What is a jury member supposed to think? Are they just supposed to think that she allowed her children to be murdered because somebody else did it and she didn't know nothing about it? I would be mentally incompetent or whatever if I didn't even know where my children, I don't understand why the defense thinks that the state can't sit there and bring out an expert talking about she's not mentally ill, because they know, y'all, the state knows when all this shit comes out about her belief system, they endorse to espouse religious beliefs for the purpose of murder. The defense thinks, well, if the state can't talk about, evildoers and evilness and that she doesn't have a mental illness, the jury members are going to think she's mentally ill, and we don't have to bring out a mental health defense. That's what the jury members will think. You see? And then, if she does get convicted, then Archie can talk about it all he wants, which would back everything up that the jury members thought in the first place, because the state wasn't able to say she's not mentally ill. There's a difference between religiosity and someone using religion as an excuse to commit crimes. I think it's pertinent, and the state has the burden. The state is the one that has to put their case on. And if they think that this Dr. Wellner needs to be there to explain these things, I don't see how Archie's going to get his way in this, and this can't be and won't be any form of an appellate issue. It's how it's laid out, and we're going to watch it lay out. So anyway, those are the recent motions. We've gotten our announcement that East Idaho News, Nate Eaton specifically, is going to be getting the audio. We're going to hear it every day. We're going to keep our support strong for Cresha as she goes to this trial, Kay and Larry. And we'll wait for them if they have something they want to discuss about what they're seeing, because they are the priority in all of this. Wayne and I feel good about the decision not to attend the trial. We know it's what's best. We want to show respect and honor to Kay and Larry and Cresha. We don't want to be in the middle of all that. We will get justice through understanding together. Yes, we'll get the audio. That's the best we can do. There'll be some live tweeting, I'm sure. I'll post all that on the community wall. We'll get together every evening. I'm going to need y'all. We're going to see this through, y'all. We're going to see the adjudication of this case through to the very end. We will get justice through understanding. So anyway, leave your comments. Let me know what you think. We'll get back together real soon. A lot of stuff's starting to drop in the portal. Those are some of the things I wanted to get to initially. We need to get to jury questionnaires, jury instructions, specifically out of Idaho. We're going to go over that. We're going to learn as much as we can. You can educate me, and we can work together, and we'll get this all put together. Justice is coming, y'all. It might not be the way that we wanted it. We wanted to see the cameras in the courthouse. But we're just going to make do with it. We're going to make do with what we have. And we are going to pray and have our thoughts with Cresha and Larry and Kay and the rest of the victims' family members. It's working out exactly the way it needs to. I've got to feel right in my heart about stuff. Wayne specifically, said some things to me after we got this news yesterday that I'll just keep to myself. But I trust my husband, and I'm sorry to disappoint all of y'all on that. But you know what? It's not about me. It's about justice through understanding, and it's about being there for the victims' families members. That's basically what it comes down to. So I love you all, and keep on looking.